Respected dignitaries, honored guests, ladies and gentlemen, as we are about to start our program, may I request you all to kindly be seated. We invite our esteemed dignitaries and guests to occupy the distinguished chairs on the dais.
It is indeed a privilege to welcome you to this momentous occasion. Today, we celebrate a pivotal moment in our legal system's evolution, one that reflects a deep commitment to innovation and excellence in the administration of justice. The establishment of Arbitration Center in the High Court of Kerala, the first of its kind, is not merely a logistical enhancement. It is a visionary step towards embracing alternative dispute resolution, providing parties with a specialized, efficient, and cost-effective means to resolve their conflicts.
Apart from the esteemed speakers on the dais, we acknowledge the august presence of Honorable Mr. Justice C.S. Dias, Honorable Mr. Justice T.R. Ravi, Honorable Mr. Justice S. Manu, members, Board of Governors of the Arbitration Center, High Court of Kerala, and Sri Pravash Pandey, Joint Secretary, E-Courts, Justice and National Judicial Academy, Department of Justice, Ministry of Law and Justice, Government of India. Without further ado, let's commence this heartening occasion. May we now invite Sri S.K.L. Vargis, Senior Advocate, High Court of Kerala, and a doyen in the field of arbitration to felicitate the day's function.
Presiding officer of the session, Honorable Justice Suresh Kumar, and other companion judges, dignitaries on of the dais, and my dear friends. At the outset, I have an apology to you all because I have to limit my salutation because I like to see of dignitaries on the dais. If I am going to address each and every one in the befitting way, it itself will take a lot of time. So I may be pardoned if I am wrong. Coming back to my role, I know it's a limited role for me, just to felicitate the occasion. At the same time, I seek your permission, because as just now announced, I have been in the field of arbitration for quite some time. This year we are completing, my friends, we are completing 50 years in the profession. And mostly I had occasion to go to various places in India for arbitration. And also for the same reason I had to appear in many other high courts as well. One unique feature I have witnessed there, I just want to share with you and stop it there. See, as you know, the prestigious high courts like Bombay or Delhi, they have got original jurisdiction also. There is the commercial suits, almost all the suits come, high stakes suits come to the commercial courts in those courts. They do not, the judges do not readily into plunge into taking trial, going for trial and lengthy argument. I just ask the advocates. Of course, they know what is the matter, but they ask them, what is the point of issue, what is the matter about? And the learned judges make them admit that it is a matter involves business. Either there is a dispute between two business people, or relating to construction works or export and import. And they will tell them, the learned judge will tell them, see, in order to resolve these types of disputes, the best way is arbitration. You can explore the possibility of mediation also. If the advocates are a little reluctant, they don't mind asking them to bring the clients to the court, and the short dialogue, they convince the clients also that, see, arbitration is the best remedy for them. In fact, clients are more happy. They appreciate the practical wisdom of the learned judges, and they go for arbitration, and within a short time it will be it's result oriented. Why I refer to that at this instance only to suggest or rather request our learned judges in the High Court also, when occasion arises, if they feel that the subject matter can be better resolved in arbitration, they should use their good office to advise the advocates and probably if necessary the clients also. That is, you are business people, you want to do business rather than litigation. Better you go for arbitration. We have got a good panel here, conversing with all the subjects, whatever you can choose your own judge. It will be quite a congenial atmosphere. You don't have to enter the witness box and face embarrassing questions. In an arbitration, very calm and cool across the table, you can discuss the matters. The person who is the arbitrator can understand what is your subject and give a solution for your problem very easily. I hope, and the learned judges will use their good office for that purpose. At the same time, I am aware, in our High Court, we have only appellate or revisional jurisdiction, but at the same time, the learned judges can advise the judicial officers in the lower judiciary that they should, they also, because now Section 89, which was incorporated in the statute after the Justice Malimat Commission recommendations, that provides for arbitration first, then only comes mediation and conciliation. Whereas, when a matter comes to the court, the civil court comes, the matter is sent to mediation. If it is not workable, it comes back to the court. I would submit the learned judges should advise the lower court judiciary also, or embolden them to explore the possibility of arbitration, because that will be ease their work also. You know, the lower court judges are having a tedious roll call that may go up to lunch time. After that, number of IAs on this side and number of list cases on the other side. I don't know, I wonder whether they will be able to breathe even properly. In such a situation, it will be a matter of consolation for the judges in the lower judiciary also to explore the possibility of arbitration. So my humble request is on this occasion that our learned judges should use their good office to promote arbitration, and I am sure that that will be a good idea for dispute resolution mechanism and render justice to our litigants. I know I can speak a lot on the subject, but I know my limitations, so I stop at that. Thank you very much. All the best.
Thank you, sir. Your enlightening words has truly enriched us.
May we now invite Sri Ashwin Shenai, President, Kerala High Court Advocates Association, to felicitate this event.
Honorable Union Minister, Mr. Sri Arjun Ram Meghwalji, Honorable Acting Chief Justice, Justice Mohammad Mushtaq, Justice P.B. Suresh Kumar, Justice Dinesh Kumar Singh, the judges of this court, Sri A.R.L. Sundaresan, Additional Solicitor General of India, Sri Hibi, Member of Parliament, Sri Ajit T.S, Chairman, Bar Council of Kerala, Shri N. Manoj Kumar, State Attorney, and the dignitaries on of the dais, and my dear friends. What I would like to say is better late than never, because in most high courts, the arbitration center had come at least a decade before today. Because, but one thing we need to point out is that Justice Mohammad Mushtaq grabbed his opportunity with both his hands. He has been an acting Chief Justice for just about a month now, and he have immediately grabbed that opportunity of establishing an arbitration center. So it doesn't matter who does it. What matters is, do we have it? And we are certainly having it from today. So the most important aspect on arbitration, I do not want to take too much time because there are too many speakers out here. But again, why is India not a good jurisdiction for arbitration when we think about is for a very simple reason, that after arbitration, we still get entangled in the legal system. The best example is the Delhi Metro case. After the arbitration, they went to the single judge, before the single judge in Delhi High Court, division bench, Supreme Court, review, curative. And curative, the entire thing was reversed. So when a court system is still not accepting arbitral awards for its value, what happens is we decrease the entire value of the arbitration system, because what people see it is one extra step to litigation. Nobody is seeing it as a quicker solution to arbitration. Therefore, what I would request the courts is this, that we need to use the Singapore model where the court's interference in arbitration is limited to very, very limited grounds. As long as you do not limit these grounds of appeal, arbitration has never worked and will never work. And therefore, I would point out with this simple, small suggestion, and I would also be happy if the network that we established through this arbitration center is institutionalized. That means we have institutionalized rules to be followed. Otherwise, what happens is, today in most of these cases, like what we speak is the small loans that people take to buy a car, to buy a house. What happens is arbitration. I happen to defend one of those cases, and the first application I made was, I asked the independence of the arbitrator. He says, yeah, I am independent and impartial. The next question I asked is, of this particular company, how many arbitrations did you do in a year? The answer was 800. So his entire income comes only from that one company. But that system has thankfully been changed because we are having new rules come up. But this will tell us the gist of why arbitrations don't work in the country, and I believe that we will have a system which works and which gets the burden on the courts decreased much further. Thank you so much.
Thank you, sir.
We now welcome Sri Ajit T.S, Chairman, Bar Council of Kerala, to offer felicitation on the day's function.
Honorable Union Minister of Law and Justice, Sri Arjun Ram Meghwal, His Lordship, Mr. Justice Mohammad Mushtaq, Acting Chief Justice, Honorable Mr. Justice P.B. Suresh Kumar, Honorable Mr. Justice Dinesh Kumar, members of the Board of Governors, Honorable Mr. Justice C.S. Honorable Mr. Justice T.R. Ravi, Honorable Mr. Justice S. Manu, Sri Hibi, Member of Parliament, other eminent judges who have joined here this momentous function, the respected senior lawyers, the very eminent members of lawyers community, the President, Kerala High Court Advocate Association, Sri N. Manoj Kumar, State Attorney, my dear friends. Today, we gather to inaugurate the Arbitration Center as well as the dedicated website for the Arbitration Center, working under Honorable High Court of Kerala. Arbitration offers a valuable alternative to traditional litigation for resolving disputes and should be more widely recognized across the state. The Arbitration Center brings numerous benefits such as it promises speedier resolutions, maintains confidentiality, allows flexibility in choosing arbitrators, leverages expert knowledge, and can be more cost effective. Additionally, arbitration awards are binding, ensuring finality in disputes. I extend my gratitude to the team led by our Acting Chief Justice, Mr. Justice Muhammad Mustaq, and the eminent judges in the Board of Governors for their efforts in making this project a success. Thanking you once again.
Thank you, sir. May we now invite Sri M. Manoj Kumar, State Attorney, Government of Kerala, and Executive Vice Chairman, Bar Council of India, to address this gathering.
President of the meeting, Honorable Mr. Justice P.B. Suresh Kumar, Judge High Court of Kerala, and the Executive Chairman of the Arbitration Center, Shri Arjun Ram Meghwal, Honorable Minister of State, Ministry of Law and Justice, Government of India, Honorable Mr. Justice A. Muhammad Mustaq, Acting Chief Justice, High Court of Kerala, Honorable Mr. Justice Dinesh Kumar Singh, Judge, High Court of Kerala, and President, Board of Governors, Arbitration Center, Honorable Judges on and off the dais, dignitaries on and off the dais, ladies and gentlemen. Today, we gather here to mark a significant milestone in the legal landscape of our state, the inauguration of the Arbitration Center at the High Court of Kerala. Arbitration as a dispute resolution mechanism has grown beyond leaps and bounds in our country in the recent past. Recourse to arbitration has become a sine qua non for dispute resolution across the country, particularly in commercial transactions. Institutional arbitration has achieved phenomenal altitudes all over the world with the establishment of many premier institutions. It is certainly on a growth trajectory in our country as well. The Arbitration Council of India frames policies for grading institutions and promoting institutional arbitration by strengthening arbitral tribunals. Institutional arbitration offers several advantages. It provides a structured framework and administrative support for the parties to the arbitration throughout the arbitration process by arranging hearing venues, by facilitating filing and fee payments, scrutinizing draft awards, etc. It enables to have a flexibility in the timeless proceedings and regulates the entire arbitral process. It affords clarity and certainty on a range of procedural issues. It expedites the constitution of an arbitral tribunal as well. It increases the credibility of the arbitration process by deciding on the challenges to arbitration in a transparent and impartial manner. Reportedly, the Arbitration Center of the Kerala High Court, being inaugurated today, intends to provide an avenue for dispute involving the Government of Kerala also to be resolved by arbitrator who is a serving judicial officer. The same, according to me, will certainly guarantee an impartial and unbiased resolution of commercial disputes involving the government. I am confident that the Arbitration Center will provide a structured and streamlined approach to dispute resolution, and it will offer a cost-effective and timely solution for parties involved, guarantee procedural justice, facilitate faster and easier enforcement of awards. This will certainly result in converting our state into a leading hub for legal and commercial arbitration. On behalf of the law officers of the state, I wish the Arbitration Center at the Kerala High Court a great success in its endeavors. Thank you. Jai Hind.
Thank you, sir. Sri A.R.L. Sundaresan, Additional Solicitor General of India, holds a deep connection with our court. His father, the late Honorable Mr. Justice A.R. Lakshmanan, served as a judge of our Honorable Court before ascending to the highest court of the country. Given his distinguished lineage and personal ties to our court, Sri A.R.L. Sundaresan is befitting to felicitate today's function, making his presence all the more meaningful to us. Sir, please.
Honorable Shri Arjun Ram Meghwal, the Honorable Minister of State for Law and Justice, the Honorable Acting Chief Justice Mohammed Mushtaq, the Honorable Justice P.B. Suresh Kumar, the Executive Chairman of the Arbitration Center, Honorable Justice Dinesh Kumar Singh, President of the Board of Governors, the other Honorable Judges of the Board of Governors of the Arbitration Center, Honorable Judges of the Kerala High Court, Senior Advocates, my friends, ladies and gentlemen. Anaivarukkum Namaskaram. It is really a proud moment for me to be a part of this function where the Arbitration Center of the Kerala High Court is inaugurated. Arbitration provides a purpose. It has a purpose. One is alternate dispute resolution, reducing the burden of the courts. The other one is a remedy to the client in a time-bound manner and with less formalities. And if the High Court itself sets up an arbitration center, then the purpose will be achieved because it will instill confidence in the clients that this is a responsible institution which is starting an arbitration center, and therefore if we go there we will be able to have the arbitration done in a proper way and the procedures would be fair to both. And I also understand that there are going to be a panel of arbitrators enrolled here, and appointments will be made on a case-to-case basis, and therefore if instead of the parties themselves identifying the arbitrator and coming forward with allegations of bias, etc., if it is an institutional arbitration at the instance of the High Court, then such complaints may be far too less. And we will have to congratulate the High Court for coming forward to set up this arbitration center. And I can say with confidence that the Madras High Court has set up an arbitration center about 8 or 9 years ago. Rules have also been framed and it is functioning efficiently, and I have no doubts that the Kerala High Court Arbitration Center also would do so. Thank you very much.
Thank you, sir.
Sri Hibi Eden, Member of Parliament for Ernakulam, is known for his dedication to serving the people beyond the realm of politics. With unwavering vigor and spirit, he consistently raises the concerns of his constituents in Parliament. His commitment to public service makes him the ideal person to felicitate today's function. May we request Sri Hibi Eden, Member of Parliament for Ernakulam, to render his felicitation address.
The President of today's function, Honorable Mr. Justice P.B. Suresh Kumar, our very own Chief Guest, Honorable Minister for the State for Law and Justice, Honorable Arjun Ram Meghwal ji, Honorable Acting Chief Justice, Honorable Justice A. Mohammed Mushtaq, distinguished judges on the dais, presidents of different associations representing lawyers of the High Court, friends from the legal fraternity, friends from media, students of law, and dear friends. It's a great honor and privilege for me to be a part of this very auspicious gathering. Due to many reasons, one is that the Honorable Minister himself has been present to inaugurate this arbitration center. Today I told the Honorable Minister that we have a very auspicious day. Chingam Onna is a New Year for Kerala, which is again a bright day for Keralites. We all understand that arbitration is a very key word in the legal fraternity system. Many of us know the importance of an arbitration center. Even late, we have it here today. I would congratulate the entire team, the Acting Chief Justice and his entire team of distinguished judges for initiating this process. But at the same time, I would agree with the President of the Bar Association, where he has very clearly told, even though we have dispute resolutions done in an arbitration center, the award is again done in a court of law, where again it is a time-consuming process. So again, a layman is spending more time after the arbitration center, even though there is a prescribed time and format for implementing the case disposal, but unfortunately in many cases it doesn't happen. So I believe that you are not responsible. I think me and Arjun Megwalji is responsible. I think we should amend the law in the central government. And I would assure you one thing, that if you bring such a law, we would unanimously pass that law. No, bilkul nahi. He is always considering me as the shouting brigade in the parliament. So he always has, so he always has certain concepts about that. So I would assure you on this very auspicious day, the very intent of the arbitration center itself would be hampered if the resolution disposal happens again at a slower phase. When we look at the Crime Records Bureau, sometimes the Honorable Minister would be astonished to see that Kerala is in the leading, sometimes in the forefront in every crime, but it is not the matter. In fact, the lawman's perspective, the kind of system of education we have, the kind of legal knowledge our laymen have is something which is very important. That is why whenever an issue happens, when an incident takes place, we have no regret in going to the police station and lodging a complaint. So according to the Crime Records Bureau, in most of the cases, Kerala would be in front of the, in the leading in terms of crime, but it is not actually, the numbers are actually not in that matter. But as I said, every lawman is aware of the law in this country in perspective of Kerala. So we have a system designed in such a way that we have more cases at disposal. So the arbitration center is a very welcomed decision, but I would also request the Honorable Minister and the experts in this fraternity to look how we can dispose this without a court of law, or much faster phase, how can we dispose this. So I congratulate again the entire team for bringing the arbitration center to the very historical city of Cochin and the High Court of Kerala. Thank you. Jai Hind.
Thank you, sir. We regret to inform that Sri P.A. Mohammad Riaz, Honorable Minister for Public Works and Tourism, Government of Kerala, is unable to attend the day's function as scheduled, as he had to urgently travel to Wayanad to manage matters related to the recent natural disaster.
Honorable Mr. Justice A. Muhammad Mustaq has made an invaluable contribution to the establishment of the Arbitration Center, playing a pivotal role in its creation. Under his visionary leadership, this center has become a reality. His dedication has been instrumental in setting a new standard for dispute resolution. May we request Honorable Mr. Justice A. Muhammad Mustaq, Honorable Acting Chief Justice of the High Court of Kerala, to launch the dedicated website of the Arbitration Center, High Court of Kerala, by unveiling the digital plug. So we also request you to kindly deliver the keynote address as well.
The president of this event, my colleague, Justice P.B. Suresh Kumar, the chief guest of today's function, Honorable Sri Arjun Ram Meghwal, the Minister of Law and Justice, my esteemed brother, Justice Dinesh Kumar Singh, the President of Board of Governors of Arbitration Center, my esteemed brothers, Ravi, Justice Manu, T.S, and other brother judges and sister judges who are here, other honorable dignitaries of the on and off the dais, the mediators, lawyers, judicial officers and others, and law students. It's indeed an historic moment for all of us. Law Minister readily agreed to come over here and inaugurate this arbitration center without any hesitations. We are much grateful to you, Honorable Law Minister, for readily agreeing to inaugurate this arbitration center. 3 years ago, when I decided to establish this arbitration center, a lot of discussion happened. We made rules with assistance of Senior Counsel S.K.L. Vargis. Of course, in the meanwhile, amendments came, so we dropped the idea meanwhile. Again, Mr. Brother Dias asked me to continue, we should launch the arbitration center immediately. So we, from the dustbin, all the rules, we got it up. We got the rules from other states, and the Director Jubia collaborated, discussed with many, and it's almost finalized. We have a unique arbitration rules. The serving judicial officer, as pointed out by State Attorney, will be on serving the arbitration center on deputation. Both state and government or central government need not pay any fees, and they are totally exempt. Of course, it's not an exemption, they need not pay any fees. So as to ensure that central government and both state government refer their disputes or make mention in the contract for reference to the arbitration center. The Kerala government in policy has not keen in referring to the dispute arbitration center after the issue related to the Kallada projects. Even Kerala government legislated to nullify the clauses in the arbitration, arbitration clauses in the contracts entered with the contractors. Of course, there was a challenge against those legislation. Ultimately went up to the Supreme Court, and this Supreme Court upheld the challenge, holding it as unconstitutional. I hope the Kerala government will again show the interest in referring to disputes at arbitration center. Because often we find large number of disputes are coming in through writ petitions under Article 26 to the High Court. And both government as well as contractors find it difficult to have a kind of adjudication in formal system because of large volume of evidence is involved, and kind of nature of evidence is it's not easy to prove such a dispute, and complying with the formalities required to be followed under the Evidence Act. So I hope both central government and state government will keen referring the disputes to the arbitration center. Well, as many may not be aware of it, we have a great tradition in the past underscoring the importance of arbitration. The British understood how important for Indian traditions to resolve the dispute beyond the formal system. In Bengal Regulation made in 1872 and followed by Bombay Regulation and other regulations, British recognized those arbitrary tribunals and allowed parties to choose their own arbitrator to settle the disputes. But somehow we've given up our traditions, and present enactment came in 1996. It's something is as imposed on us by super bodies, a uncitrol model. It has a specific goal to cater the business requirement of those who are investing in our countries and other countries. This is how they made the model law. So uncitrol model we follow in our country, which of course would enable a faster dispute of resolutions, subject to the challenge to be made before the formal system, before the High Court and the superior courts. But given that context, we look at the arbitration enactment, we'll see that it is largely framed in such a way to promote business interests and commercial interest. Looking at our past, the traditions we followed, we don't find that this arbitration enactment is completely conducive to the Indian context. The traditional system, the artisans, and all other sector or segments, they have a kind of system evolved within them to choose an arbitrator and resolve the disputes. Somehow that great traditions have been now found revived in mediation enactment. Once it comes to force, we will find some sort of revival of our earlier traditions because it recognizes the community mediation and other form of dispute resolution. So it should percolate to the grassroots level. People should be able to settle the disputes in most expedient manner without incurring much cost and expenses. Today, people are looking at the arbitration as a mainstream. They find that it's costlier. Of course, arbitration enactment brought somewhat scale down the fees being levied by arbitrators. We need to look at those people who cannot otherwise afford the mainstream justice system for resolve their disputes. So mediation enactment, some level, will bring certain amount of the resolution of disputes in an easiest manner, inexpensive manner. But I still feel somehow we need to have a kind of a mechanism of med-har, both mediation and arbitration. If it is not could be settled in the mediation, then it should be resolved through arbitration. That should be our aim. I think that combination, the hybrid form of resolution of a dispute, will certainly bring a new approach in settling the disputes. We always need to keep in mind the courts are the public institution and it should spare its time and resources for larger public course and in larger societal interest. All sort of private disputes should be resolved otherwise, so that court can spare its time and focus on larger public causes. If you look at the statistics here, in any other courts, the long pendency of criminal matters, we have a criminal revisions of age 20, spending a year on more than 25 years and 20 years. We cannot pay attention to those cases because of we handle large volume of cases. We have total 2.5 lakhs cases. So we need to have a policy in place to promote ADR mechanism and to see that our service in the formal system is more focused on larger public interest and societal interest. This is the only way we can promote ADR. So to promote ADR, of course, we need to have institutional standards. It is only through the institutional standards we can achieve. That's exactly the reason, ad hocism exactly the reason the government withdrew from arbitrations. The Kerala state government withdrew from arbitration because it is prone to corruption or other kind of allegations. Now we need to ensure this a credible platform to the commoner and other litigants and those who want to resolve their disputes through this platform. I assure you that this arbitration center will rise up to the challenge and win the confidence of the litigants and others. With this word, I conclude. Thank you one and all. Once again, I thank Honorable Minister coming over all the way from Delhi to here for this program. Thank you one and all. Jai Hind.
Grateful to you, sir.
We have the honor of inviting Honorable Mr. Justice Dinesh Kumar Singh, Judge, High Court of Kerala, President, Board of Governors, Kerala High Court Arbitration Center for a special address.
Shri Arjun Ram Meghwal ji, Minister of State for Law and Justice, my brother Justice Muhammad Mustaq, the Acting Chief Justice of Kerala High Court, Justice P.V. Suresh Kumar, the Executive Chairman of the Arbitration Center of High Court of Kerala, Mr. Justice T.R. Ravi, Justice Reyes, Justice Manu, Mr. Lakshman Sundaresan, A.R.L. Sundaresan, the Additional Solicitor General of India, the Ashwin, the President of the High Court Bar Association, other honorable judges of the dais, senior advocates, lawyers, students, arbitrators. Today we have gathered here to mark a momentous occasion in the annal of the Kerala High Court. We are inaugurating the Arbitration Center in the High Court, which is a watershed movement, a testament to our collective resolve to revolutionize the way we approach the judicial justice and dispute resolution. Arbitration concept is not new in this country. As a method of resolution of disputes, it has a rich history dating back to ancient civilizations. The concept of arbitration was first mentioned in the court of Hamburg by around 1754 BC. The first formal statute relating to arbitration in India was the Indian Arbitration Act 1899, applicable only to presidency towns of Madras, Bombay and Calcutta. Subsequently, after the Code of Civil Procedure 1908 came into vogue, the second schedule of the said code provided for the regime of arbitration. The aforesaid statutes, which form the basis of arbitration in India, subsequently gave way to detailed legislation relating to the arbitration titled Arbitration Act 1940. This was a significant milestone, followed by the Arbitration and Conciliation Act 1996, which is based on the unilateral model of arbitration. This 1996 Act has consolidated and amended and repealed the earlier laws on arbitration. It brought our country in line with international best practices and established a framework for domestic and international arbitration. This Act has been amended several times, including 2015 and 2019, to further strengthen the arbitration regime in India. It was enacted to provide a comprehensive framework for domestic and international arbitration and to align our country with international best practices. The concept of party autonomy, which follows parties to choose their own arbitrators and procedural rules, the provisions for fast-track arbitration, which enables to opt for an expeditious arbitration process, are some of the salient features of the 1996 Arbitration Act. Today, we are taking another significant steps forward with inauguration of this arbitration center under the dynamic leadership of our acting Chief Justice, Mr. Muhammad Mustaq. He has special knowledge and the love for the arbitration. Whenever I discuss, he has this idea and he grabbed this opportunity, being the acting Chief Justice of India, and inviting Mr. Meghwal to inaugurate this center. I am sure the center will provide a conducive environment for arbitration proceedings. ensuring that justice is served with utmost efficiency. I must ensure and assure Mr. Shenai that we are framing the rules at par with any other arbitration center in the country, and we will provide these institutionalized arbitration. Arbitration as a method of dispute resolution has gained immense significance in recent times, particularly in commercial disputes. We have now the commercial courts as well, but we see the commercial disputes take a lot of time to get them resolved. The arbitration offers a platform for parties to resolve their disputes in a fair, expeditious, and cost-effective manner. That is another thing, that how it is cost-effective. But the purpose is to have a system of dispute resolution, particularly commercial disputes, in a cost-effective manner. This center, I am sure, will provide a conducive environment for arbitration proceedings, ensuring that justice is served with utmost efficiency. This arbitration center is more than just a physical structure. It would be a beacon of hope for those seeking swift and effective resolution of disputes. It represents a paradigm shift in our approach to justice, one that prioritizes efficiency, fairness, and accessibility. As we dedicate this center to the people of Kerala, we reiterate our commitment to principles of justice, equality, and fairness. We recognize the immense trust placed on us and pledge to uphold the highest standards of integrity and excellence in the center. To the legal fraternity, I extend my gratitude for your unwavering support and cooperation. Your expertise and commitment are vital. Some of the senior advocates are here who are expert in arbitration. They will guide the center to achieve its objective in future. So let us embrace this new chapter with optimism and enthusiasm and work together to make this center a shining example of our unwavering dedication to justice, symbol of our unrelenting pursuit of excellence, and a beacon of hope for generations to come. Thank you. Thank you all.
Thank you, sir. We are pleased to invite Honorable Mr. Justice P.B. Suresh Kumar, Judge, High Court of Kerala, Executive Chairperson, Kerala High Court Arbitration Center, for the Presidential Address.
The Honorable Minister of State, Ministry of Law and Justice, Government of India, Shri Arjun Ram Meghwal, Acting Chief Justice, Justice Muhammad Mushtaq, Justice D.K. Singh, the President of the Board of Governors of the Arbitration Center, which is being inaugurated today, my esteemed brother and sister judges were present on and off the dais. Shri Hibi, Eden, Member of the Parliament, other dignitaries on and off the dais, respected senior advocates who are present, my lawyer friends, judicial officers, law students, ladies and gentlemen. Good evening to one and all. I'm deeply honored and privileged to address you on this momentous occasion which marks the beginning of the opening of the Arbitration Center of the High Court of Kerala. As pointed out by the President of the Advocates Association, and many other High Courts arbitration centers have already opened, and we are a bit late. As said by him, let us start without wasting for time. The center signifies, according to me, a commitment
to swift, fair, and effective justice. Arbitration has now become indispensable for resolving commercial disputes, especially those involving governments and its instrumentalities. It offers a more efficient and flexible alternative to traditional litigation. Unlike ad hoc arbitration, institutional arbitration carries with it certain advantages, and these advantages are the cornerstone of our new center. Institutional arbitration offers a structural and reliable process. When parties choose institutional arbitration, they are guided by established rules and procedures. These rules ensure consistency, fairness, and transparency. Another advantage institutional arbitration offers is the administrative support. Institutions would provide logistical and procedural assistance, making the process of arbitration smoother for all parties. This support is crucial in complex disputes, especially those involving government entities where clear procedures are vital. Institutional arbitration also offers a panel of experienced arbitrators. These arbitrators are not only experts in the field of law, but also in the specific industries relevant to the dispute. This ensures decisions are informed and grounded in practical knowledge. One of the most significant benefits institutional arbitration offers is its enforceability. Awards granted by institutional arbitration centers recognized by the people carry weight and are easier to enforce. This is particularly important in disputes involving government and public bodies. The credibility of institution adds to the authority of the award, which I wanted to give emphasis. The credibility of the institution adds to the authority of the award. Confidentiality is another key advantage of institutional arbitration. Institutional arbitration ensures that the procedures are private, protecting sensitive information from becoming public. This is crucial in government-related disputes where confidentiality can be a matter of national interest as well. Furthermore, institutional arbitration offers finality. The decisions are binding with limited grounds for appeal. This provides a clear and definitive resolution, allowing parties to move forward without prolonged uncertainty. The arbitration center we are inaugurating today embodies all these advantages. It is designed to handle complex commercial disputes efficiently and fairly, particularly those involving governments and their instrumentalities. This center will serve as a model for how disputes should be resolved in today's fast-paced and complex world. I express my gratitude to the Honorable Minister for the support extended for establishing this center by his gracious presence. Your presence also reflects the importance of this initiative. To my fellow legal professionals, I would request all of you to utilize the center and promote the institutional arbitration as the preferred method of dispute resolution. Together, we can ensure that justice is not only served, but served promptly and effectively. Thank you.
Thank you, sir. Sri Arjun Ram Meghwal, Honorable Minister of State, Ministry of Law and Justice, Independent Charge, Government of India, has demonstrated his unwavering commitment by traveling to this part of the country to formally inaugurate this pioneering initiative. His passion for strengthening the legal landscape, particularly in the area of alternative dispute resolution, highlights the national significance of this momentous occasion. It's our honor and privilege to invite Sri Arjun Ram Meghwal, Honorable Minister of State, Ministry of Law and Justice, Independent Charge, Government of India, to formally inaugurate the Arbitration Centre, High Court of Kerala, and dedicate its services to the state by unveiling the digital plaque. Now that the centre is formally inaugurated, sir, it's a pleasure to invite you to address this august gathering.
The occasion of the inauguration of newly established arbitration centre at the High Court of Kerala. And on this occasion, on the dais, Honorable Justice A. Muhammad Mushtaq, Acting Chief Justice of High Court of Kerala, Honorable Mr. Justice B.P. Suresh Kumar, Judge High Court of Kerala, and Executive Chairman, Arbitration Centre, High Court of Kerala. Honorable Mr. Justice Dinesh Kumar Singh Ji, Judge High Court of Kerala and President Board of Governor, Arbitration Centre, High Court of Kerala. Honorable Justice C.S. Dice, Judge High Court of Kerala. Honorable Justice T.R. Ravi, Judge High Court of Kerala. Honorable Justice S. Manu, Judge High Court of Kerala and Member Board of Governor, Arbitration Centre, High Court of Kerala. Shri A.R.L. Sundaresan, Additional Solicitor General of India. Shri N. Manoj Kumar, State Attorney Kerala and Executive Chairman of Bar Council of India. Shri Ajit T.S, Chairman Bar Council of Kerala. Srimati Jubia A, District Judge and Director, Arbitration Centre, High Court of Kerala. E.B. Hidden, Member of Parliament of Cochin, Ernakulam, and Sri P.P. Pandey, Joint Secretary, Department of Justice. Honorable former and present judges, Advocates General of State, other senior advocate, students, friends from media, and ladies and gentlemen, very good afternoon to all of you. Chingam first. It's okay, na? Chingam first. First, I will tackle our friend in Lok Sabha, Hibi Hidden. I am from Treasury side and he is from opposition side. He has given some suggestion to me and it is a good suggestion. If you all agree, then two proposals are under consideration in arbitration's matter. One is, generally, it is a challenges in arbitration field. Set aside arbitration award on formal ground. Some grounds are listed, but sometimes we have seen that the set aside arbitration award on formal ground, that is under consultation process. If you support us, then we can support. No dispute, na? Okay. And second issue of the fee issue, that is also issue. You also, I think, who has told this fee issue? Sign? Achha, you also spoke and I think Yashwant Sehni has also spoken, no? As you don't speak about fee. Retired judges are taking, na? It is a issue. So somebody is told, I think, K.L. Vargis.
Yes, I shared you when you were.
Then you all.
The speech also mentioned.
Somebody mentioned in the speech, Vargis, I think, no? Somebody mentioned. But can you support it?
There should be a bar.
Okay. When we fight in parliament each other, there is also arbitrator. Otherwise, speaker is the arbitrator. You know, na? You know. So in every field, we need arbitration, and arbitration is our ancient practice. As our acting Chief Justice told me when we were discussing that in which act you are mentioning, I think the Bengal Regulation Act, it was mentioned, then you can choose the arbitrator. We are also in the process, in consultation process, and we can do it. I can assure you, in Mediation Council Act, we amended in Parliament, and we can do it, because we can give the choice to those who are fighting each other. We can give the choice, you can choose the mediator. In inaugural event is a moment of reflect upon the evolved role of judicial fraternity in the larger arena of good governance, architecture, and their purposeful role in the upcoming future. Friends, as you know, disposing of pending cases is a huge challenge for us. The government has been constantly endeavoring to provide an ecosystem for the faster and more efficient disposal of cases by the judiciary. Establishing of the Arbitration Center shows our commitment to promoting alternative dispute resolution system. It is a part of ADR, Alternative Dispute Resolution System, or you can say mechanism. A successful settlement helps preserve the relationship among the parties, offers ease of living, and contributes to the growth of the economy. Arbitration, mediation, and conciliations have become better substitutes for conventional dispute resolution methods. Dear friends, I would like to recite the line are from Ramdhari Singh Dinkar. He was the famous poet. That is in Hindi, but I can translate in English. Lord Krishna was the first arbitrator, you can say, or you can say the mediator. When Kaurav and Pandav are fighting each other, then at the last result, Lord Krishna has gone as a mediator. And what Lord Krishna has offered to the Kaurav from the side of Pandavas, that in Ramdhari Singh Dinkar has written, Nyay do, it is a justice. Nyay do agar tum adha do. If you can provide justice, then you give us half. It is a proposal from Lord Krishna. He was the mediator. You can say arbitrator. पर इसमें भी यदि बाधा हो तो दे दो केवल 5 ग्राम. Means, but if you, even that is too much to ask, then just give us 5 small villages. It was the proposal. रखो अपनी धरती तमाम, हम वहीं खुशी से खाएंगे. If you can keep the rest of your vast land, you will live there, we will live there happily. आगे और कहते हैं वो, and you will not raise a weapon against our kin, but even this Duryodhan could not give, nor could he earn the blessing of the society. Instead, he tried to blind the divine, attempting the impossible when destruction looms over a person. It's a highlight of the poet. When destruction looms over a person, first their wisdom fades away. नाश मनुष्य पर छाता है, पहले विवेक मर जाता है. दिनेश कुमार जी अच्छी तरह से समझेंगे इसको. It is very famous, large, ये रामधारी सिंह दिनकर का. The message conveys that the minimal solutions can be accepted, avoid conflict. It is the message. It is our tradition also. Lord Krishna communicated that it is a very minimal solution. You can accept it. But when it is not accepted, illogical things, then there is a fight. But due to arrogance and lack of wisdom, Duryodhana does not accept. This poem presents profound thoughts on power, justice and wisdom. Initially, the Arbitration and Conciliation Act was enacted in 1996, as our Acting Chief Justice of Kerala High Court has told, with a view to consolidation and amend the law relating to the domestic arbitration, international commercial arbitration and enforcement of foreign arbitral awards. Since 2014, the arbitration law has undergone significant changes in 2015, 2019 and 2021 to keep pace with changing paradigms in the arbitration landscape and enable arbitration as a viable dispute resolution mechanism. The changes signal a phenomenal shift in ensuring the timely conclusion of arbitration proceedings, minimizing judicial intervention in the arbitration process and enforcing arbitral award. Friends, now I will share a glimpse of legislative intervention undertaken by the government in this context. The Arbitration and Conciliation Amendment Act 2015 provided for expedites, fast tracks and time-bound arbitral proceedings, neutrality of the arbitration and cost-effective delivery mechanism. Second, the Arbitration and Conciliation Amendment Act 2019 aimed to boost institutional arbitration and reduce the share of ad hoc arbitration in the country. Third, the Arbitration and Conciliation Amendment Act 2021 provides for an unconditional stay of enforcement of arbitral award where the underlying arbitration agreement, contracts or arbitral awards are induced by the frauds or corruptions. Fourth, the Commercial Court Act 2015 was amended in the year 2018 to provide for pre-institutional mediation and settlement mechanism. This is aimed at providing an opportunity to the parties to resolve the commercial dispute through mediations. The India International Arbitration Center Act 2019 was enacted to provide for the establishment and incorporation of the India International Arbitration Center. Retired Justice Chief Supreme Court of India, Hemant Gupta ji, he is heading this India International Arbitration Center for the purpose of creating an independent, autonomous and world-class body for facilitating institutional arbitration and to declare the center to be an institution of national importance. The Mediation Act 2023 lays down the legislative framework for the mediations to be adopted by the disputing parties, especially institutional mediation where various stakeholders have been identified to establish a robust and productive mediation ecosystem in India. These are partial attributes of some things smoothening justice delivery ecosystem. Additionally, I would add that the government has adopted a whole of government approach to facilitate citizens' ease of life. The steps have been taken to reduce government interference in the people's life in the spirit of minimum government, maximum governance. The government used to burden ordinarily citizens with thousands of compliances. We have eliminated over 1,562 laws so that citizens are not trapped in the web of legal complexities. There were laws created for small mistakes that could send people to jail. We have abolished the practice of imprisonment for minor offences and removed provision in the law that sent people to jail. We have replaced the centuries-old criminal laws with new criminal laws known as Bharatiya Nyaya Sanhita. At the core of this, not punishment, but the idea of ensuring justice for citizens. Technology has emerged as a big enabler for digitally empowering society. Bharat has shown as testimony to it as it has marched ahead with the commencement of citizen-centric, technology-driven modern legal system. These are the initiative we have taken, and in the last, I can say you that this arbitration center, which we have opened today here in the Kerala High Court, I have seen 2-3 arbitration center. I have gone to the Delhi High Court once. There is a very good arbitration center there, and I think this is acting well, and I hope that we have opened this arbitration center in Kerala High Court, and the day is also auspicious. It's an auspicious day, na? It's an auspicious day, so I hope that this arbitration center, I think earned a name in near future. I can hope it. Thank you. Thank you. All the best.
Thank you, sir. We now request Srimati Jubia A., District Judge and Director, Arbitration Center, High Court of Kerala, to propose the vote of thanks.
Good evening, all the dignitaries on and of the dais. As we inaugurated this center, let us look ahead to a future where justice becomes more accessible, efficient and responsive to the needs of all. I will now conclude this program by extending a vote of thanks. On behalf of the Kerala High Court Arbitration Center, I would like to express my deepest gratitude to the Honorable Minister of Law and Justice, Mr. Arjun Ram Meghwal, for inaugurating this center. I also extend heartfelt thanks to Honorable Acting Chief Justice, Mr. Justice A. Muhammad Mushtaq, for launching the official website, the Honorable Mr. Justice P.B. Suresh Kumar for delivering the presidential address, and Honorable Mr. Justice Dinesh Kumar Singh for delivering the special address. I also wish to sincerely thank the Honorable Judges of the High Court, all distinguished guests and speakers, former Judges of the High Court, registrars, judicial officers, advocates, mediators, students, officers of the High Court, and the technical staff and support staff who have contributed to the success of this event. Thank you all.
Thank you, ma'am. We request all present here to kindly rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 जय